This is Marty, and today there was a hearing in federal court in Boston in front of the Honorable Judge Stearns, where my attorney, the other than Honorable David J. Grimaldi, for lack of a better term, had filed for leave to withdraw as my attorney, citing Mass Supreme Judicial Court Rule 307, Rule of Professional Conduct 3.3E2. And citing that rule, he asked for a different judge to preside over that motion than the trial judge, who is the Honorable Nathaniel M. Gordon. That rule allows him to get in front of a different judge because it basically accuses me of planning to get on the witness stand and lie under oath. And in support of this motion of his, he filed 8 ex parte sealed exhibits, which were not visible to the government, to the public, or to me. At this hearing, he sought to have the courtroom sealed, to have the prosecutors leave, the public leave, to have my wife leave, and to just have the matter heard between me and him and the Honorable Judge Stearns. I asserted my right to a public trial under the Sixth Amendment and waived my right to attorney-client privilege, or my privilege, to attorney-client confidentiality. And as per my request, the Honorable Judge Stearns kept the courtroom open. And this transcript should be available from federal court today in Boston. It was a 4 p.m. hearing in front of Judge Stearns, to anyone who wants to order it. The long and short of it is, the exhibits which Attorney Grimaldi filed in no way alleged, they didn't even allege, but on top of that, they didn't even allege, it came nowhere near anything like what the rule, again, Mass Supreme Judicial Court Rule 307, Rule of Professional Conduct 3.3E2. It doesn't even allege what is in that rule, which the presiding judge, the Honorable Judge Stearns, confirmed, because I still couldn't see the stuff that was filed under seal. So orally, the judge confirmed that before he denied Attorney Grimaldi's motion. So Attorney Grimaldi filed this motion citing this rule, didn't actually provide the factual basis to support it, had his motion denied, and basically it comes down to he accused me of planning to lie on the witness stand under oath, which I've never planned to do. And the long and short of it is, he used this rule to get in front of a different judge because he had tried to move to leave the case 10 days earlier in front of the presiding judge, Judge Gordon, who denied his motion. And I had also objected to his motion. The nature of the controversy between Attorney Grimaldi and I, there's several things, but the main one is his refusal and failure to file a motion for the recusal of the Honorable Judge Nathaniel M. Gordon from the main criminal case. I have published a draft of that motion that the whole world can see, with links in it, backing up the reasons why I feel, and I believe the average objectively reasonable member of the public would also feel, that Judge Gordon should not preside over my case. And again, it's there, it's public, it's for everyone to see. I have publicly criticized Attorney Grimaldi for not filing this motion. It is no secret that judges do not like defense counsel who file recusal motions. They are known to take it out on defense counsel who file recusal motions. I don't know if that's all of it. Of course, there's also other possibilities on top of that in terms of, let's call them illegitimate influences that might be stopping Attorney Grimaldi from filing this thing. I think especially when you look at now the level of, for lack of a better term, it seems to me intentionally falsifying the record and making false allegations against your criminal case, right? That there might be something more than just he doesn't want to file this for fear that the judges might take it out on him. But there's a great Guardian article from a few years back about recusal motions and kind of the lack of accountability on the bench in terms of this stuff, which you can hopefully find in the notes for this video. Anyway, so I wanted to make the public aware, right, of everything that's kind of happened here, and I wanted to announce that I'm filing a complaint with the Mass Federal Bar against Attorney Grimaldi for his behavior Friday in calling for this hearing and trying to do an end run around Judge Gordon for making this allegation against me, for trying to seal the courtroom, to cover up his tracks, for undermining the public's confidence in the practice of law, for all of the kind of obvious reasons around this. At the hearing, I confirmed to the Honorable Judge Stearns when he said, okay, he asked whether I was waiving, right, conflict of interest because of what my attorney had done, and I said, okay, I don't know what he's filed here, right? So I can't make a knowing waiver because I haven't seen what's filed. And the presiding judge told me what was filed, and it was my own public statements critical of Attorney Grimaldi for not filing this recusal motion. It was not anything in any way that would, even speak to his supposed reason for calling this hearing in the way that he did. And furthermore, for the record, 3 days before trial, 3 days before jury selection, Attorney Grimaldi has never substantially practiced or prepared my own testimony with me. We frankly largely haven't talked about it. It's come up tangentially a couple of times, mostly in regards to stuff that's moot now as a result of a motion to eliminate the government filed, which was granted. But we've never even talked about my testimony, which is one of the reasons why I found this so baffling, right? Because there's been no planning of any kind. And again, trial's supposed to commence in a week, so you can take that for what it's worth. And Attorney Grimaldi acknowledged this. He acknowledged that there had been no communication between the last hearing and this hearing, where he brought up this information, which he would have, had a duty to bring up as soon as it became available to me to get the camp on it, right? So he acknowledged that. He acknowledged he never worked on my testimony, and the judge acknowledged that he did not actually make the accusation that Mass Supreme Judicial Court Rule 307, Rule of Professional Conduct 3.3E2, is meant to cover. He basically wanted to do for himself what he has been unwilling to do for me. I've asked him to move for the recusal of the Honorable Judge Gordon. I don't think it's appropriate for the Honorable Judge Gordon to preside over this case for the reasons in the public recusal motion, which I have made publicly available. I don't feel I'm getting a fair hearing. Attorney Grimaldi also obviously feels that he is not getting a fair hearing, and he is hoping another judge was going to let him off the hook after Judge Gordon to do so. But he's willing to lie, basically, it seems. At least it seems. He can be your own judge. He's willing to lie, it seems, and make accusations against me in order to get this matter before a different judge, who he can then also apparently deceive in a sealed courtroom, knowing the effect would have been to damage me publicly if Judge Stearns had gone along with sealing the courtroom, which, again, I'm very thankful to the Honorable Judge Stearns for not sealing the courtroom at my request. But again, so Attorney Grimaldi, shame on you. Shame on you for the dishonesty. Shame on you for trying to throw your client under the bus. Shame on you for not filing your recusal motion, which by the way, would have headed most of this off at the pass, like a long time ago, if you just filed the thing. And then shame on you for trying to do through a dishonest purpose something that you were not willing to try to obtain from me through a legitimate avenue. And that was a fair hearing in front of a different judge. You were willing to do that for yourself if it meant throwing me under the bus, falsifying the record, and secrecy, which you know I despise. But you're not willing to file this recusal motion for me, your client. Well, the world knows that. That transcript is going to be available. The bar complaint is going to be published. And I'm very sorry that it's come to this point. It never should have. How dare you, sir?